Hello everyone, welcome back to our Learning Legal English through Case Laws series. In this video, we will study Case Law No. 2018/AL about regarding inheritance converted into assets under the lawful ownership and use of individuals. Part 1. Source of the Case Law, Part 2. Overview of the Case Law, Part 3. Content of the Case, Part 4. Assessment of the Court, Part 5. Rules. This case law was adopted by the Judicial Council of the Supreme People's Court on October 17, 2018 and promulgated under Decision No. 269/QDCA dated November 6, 2018 of the Chief Justice of the Supreme People's Court. Part 1. Source of the Case Law. Cassation Decision No. 27/2015/DSGDT dated October 16, 2015 of the Judicial Council of the Supreme People's Court on the civil case on dispute on inheritance being land use rights in Hanoi between the plaintiffs being Ms. Pham Th, Ms. Pham Th1, Ms. Pham Th2 against the defendant being Mr. Pham Van H3. The persons with related rights and obligations consisted of 12 people. Part 2. Overview of the case law. Background of the case law: houses and land are common property of the spouses, or one spouse dies first. The other spouse and other heirs of the deceased have agreed on the division of the houses and land. The division agreement is not in violation of any rights and interests of any heirs. The division of houses and land has been carried out in reality and recorded in the land documents and records. Legal resolution: in this case, it must be determined that the houses and land have been converted into assets under the lawful ownership and use of individuals. These individuals are only entitled to initiate a lawsuit to claim the houses and land that have been divided and under the unlawful possession and use by other persons who are not entitled to inheritance being houses and land. Keywords of the case law: 1. Inheritance. 2. Common property of spouses. 3. Actual division of houses and land. Part 3. Contents of the case. In the Statement of Claim for Land dated June 30, 2004 and other applications and testimonies during the proceedings, the plaintiff being Ms. Pham Th, Ms. Pham Th1 and Ms. Pham Th2 presented that their parents being Mr. Pham Van H, passed away in 1978, and Ms. No TV, passed away on August 21, 1994, had 7 children being Mr. Pham Van H3, Mr. Pham Van D, passed away in 1998, Mr. Pham Van T, Mr. Pham Van Q, passed away in 2000, Ms. Pham Th, Ms. Pham Th1, and Ms. Pham T. H2. When they were alive, Mr. Pham Van H and Ms. No TV had a house and kitchen on the land area of 464 square meters in Q District, Ha Tây Province, former name, currently part of Hanoi. In 1991, Ms. V divided the aforementioned land area between her 7 children. Each of the 4 sons was granted a part of the inheritance, and the remaining part of the inheritance, width of 3 meters located next to the street, area of 44.4 square meters, was for the 3 daughters, who are the plaintiffs. Right after being given the land, Mr. D sold it to resettle in Song B Province, former name. Mr. T and Mr. Q used the land to build houses to live. The land given to the plaintiffs was located next to the land area that Mr. V had given to Mr. H3, width of 4 meters next to the street. Mr. H3 already had houses and land in another place, so he did not use the land that he received. At that time, the plaintiffs were in the south, so Mr. H3 watched over his own and the plaintiff's land received from Mr. V, of which the total area was 110 square meters, width of 7 meters. Many years later, Mr. H3 still acknowledged that he was watching over the land area given to the plaintiffs. In 2002, at the time the plaintiffs returned to conduct reburial rites for their mother, Mr. H3 still agreed that whenever the plaintiffs were ready, they may take back the land to build their houses. However, in 2004, when the 3 sisters wished to build houses on the land, Mr. H3 refused to recognize that the land had been given to the plaintiffs and he had divided such land area among his children being Mr. Pham Van L and Ms. Pham TT. As such, he did not return the land to his sisters. The plaintiffs requested the court to compel Mr. H3 to return the land area belonging to them, which was agreed by their mother and the siblings in 1991. In the past, they requested the court to settle the case such that the sisters shall be entitled to the inheritance in accordance with the law by way of the land area of 44.4 square meters. When the People's Court of Hanoi accepted to settle the case under first instance procedures in 2010, the plaintiffs requested the court to divide the estate of their parents, being the land area of 115 square meters. The actual area was 110 m2, which was under the management of Mr. H3. The defendant being Mr. Pham Van H3, and by the testimony of his authorized representative being Ms. Pham TT, presented that, at first, Mr. H3 made statements that his parents had assets consisting of houses and land as presented by the plaintiffs. In 1972, he started a family and his parents permitted him to live on this land area of 162 square meters. After that, the defendant changed his testimony and asserted that the land area of 162 square meters were land that he and his wife being Ms. LUhenT reclaimed from garbage dump and water spinach field, on which they built a house and used up to now. This land does not belong to Mr. V and Ms. H. In 1983, Mr. H3's family moved to another place to live, but he still managed the entire land and houses of his parents and his family because at that time Ms. V and his younger sisters went to the South to participate in the new economic program. In 1987, he declared the land lot number 210 with the area of 162 square meters and was granted certificate of land use rights over the same. In 1988, Ms. V came back to her hometown and divided the land and houses among her 4 sons only and not her daughters as presented by the plaintiffs. Mr. H3 agreed with the plaintiffs' presentations as to the location and areas of land divided among Mr. D, Mr. T, and Mr. Q and his receipt of the land for use. When Ms. V divided the land, Mr. H3 agreed to give a land area of 52 square meters from his given land area of 162 square meters to Mr. Q, so his remaining land area was only 110 square meters. In 2004, he made a written document giving his children being Mr. L and Ms. T the land areas of 65 square meters and 45 square meters respectively and applied for 2 separate certificates of land use rights over them, which were not yet granted when Ms. H, Ms. H1 and Ms. H2 raised this dispute. Mr. H3 contended that Ms. V did not divide the land with respect to Ms. H, Ms. H1 and Ms. H2 in 1991 as presented by the plaintiffs. The statute of limitation for initiating a lawsuit on inheritance had expired. The land area of 110 square meters belonged to him and he disagreed with the plaintiffs' claims. The persons with related rights and obligations presented, Ms. Pham TT and Mr. Pham Van L, had the same presentations as Mr. H3. Ms. T5 confirmed that in 2003 she built a house over the land area being claimed by the plaintiffs. Mr. Pham Van T presented that the origin of the land and house was as presented by the plaintiffs. Mr. T confirmed that in 1991, Ms. V organized a family meeting and reached consensus, verbally, to divide the land for her children, in which her 3 daughters were given a part and this part was under the management of Mr. H3 along with the part that Mr. H3 was given. He confirmed that he had received his given land area and transferred it to another person afterwards. He requested the court to compel Mr. H3 to return the land in dispute to his 3 younger sisters, Ms. LUhenT and her children with Mr. Pham Van D, Ms. Phung Th4 and her children with Mr. Pham Van Q, confirmed that Ms. V had divided the land to her children but Ms. T and Ms. H4 were daughters-in-law and did not participate, so they did not know the details of the division. Ms. T confirmed that Mr. D's given land was sold by him for money to go to the South. Ms. H4 confirmed that her family has been using Mr. Q's given land for their residence up to now. As Mr. D and Mr. Q had been given land, Ms. T and Ms. H4 and their children had no requests in this case. After People's Court of Hanoi accepted to settle the case under first instance procedures in 2010, Mr. T and the heirs of Mr. D and Mr. Q had no requests in relation to the land area of 110 square meters that the plaintiffs were requesting to divide the estate, as well as agreed to give Mr. T's, Mr. D's, and Mr. Q's parts of the inheritance and land area of 110 square meters in dispute to the 3 plaintiffs and Mr. H3. The case had been undergone first instance and appellate procedures as follow. First instance civil judgment number 07/2005/DSST dated July 7, 2005 of the People's Court of QUYY District, Hatay Province, former name. Appellate civil judgment number 126/2005/DSBT dated November 30, 2005 of the People's Court of Hatay Province, former name. Cassation decision number 106/2007/DSGDT dated April 23, 2007 of the Civil Court, former name, of the Supreme People's Court accepting protest number 23/. 2007/KNDS dated March 2, 2007 by the Chief Justice of the Supreme People's Court in setting aside the first instance and appellate judgments and transferring the case to the People's Court of QUYY District to reconduct first instance procedures. First instance civil judgment number 01/2009/DSST dated April 7, 2009 of the People's Court of QUYY District. Appellate civil judgment number 87/2009/DSPT dated April 2, 2009 of the People's Court of Hanoi setting aside the first instance judgment for resettling. The People's Court of Hanoi issued decision to transfer the case the People's Court of Hanoi to reconduct first instance procedures. People's Court of Hanoi issued decision number 41/2010/QDSTDS dated July 20, 2010 suspending settlement of the case. In decision number 183/2010/QDPT dated November 19, 2010, the Appellate Court of the Supreme People's Court in Hanoi, former name, set aside the aforesaid first instance judgment and transferred the case to the People's Court of Hanoi to reconduct first instance procedures. In first instance civil judgment number 24/2013/DSST dated the 30th and the 31st of May 2013 of the People's Court of Hanoi, it was ruled, 1. To accept Ms. Pham Th's, Ms. Pham Th1's, and Ms. Pham Th2's request to divide the estate was accepted, 2. To determine that the land use rights over the land lot number 252 in cadastral map number 2 with the area of 110 square meters in Q District, Hanoi belonged to Ms. No TV and Mr. Pham Van H with value of 1,321,200,000 VND. To divide the common property of Ms. V and Mr. H, where each spouse had asset value of 660,600,000 VND, Mr. H's part of the asset was the land use rights over the land area of 55 square meters being valued at 660,600,000 VND. The statute of limitation for dividing the estate had expired. Ms. V's part of the asset was the land use rights over the land area of 55 square meters being valued at 660,600,000 VND. Each of Mr. H3, Ms. H, Ms. H2 and Ms. H1 was entitled a part being valued at 120,120,000 VND. Mr. H3 was entitled to own the assets being valued at 240,240,000 VND. Each of Ms. H, Ms. H2 and Ms. H1 was entitled to the assets being valued at 120,120,000 VND. Ms. H, Ms. H1 and Ms. H2 were entitled to use the level 4 house over the land lot number 252 in cadastral map number 2, Q District, Hanoi with the land area of 44.4 square meters being valued at 532,800,000 VND, with a map enclosed. Mr. Pham Van H3 was entitled to use a land area of 10.7 square meters. Mr. H3, Ms. T and Mr. H would continue to manage the land area of 55 square meters being the asset of Mr. H as recorded in the land lot number 252 of cadastral map number 2, Q District, with a map enclosed, because the statute of limitation had expired until the competent authorities decide otherwise. Mr. H3, Ms. T and Mr. H were entitled to the amount of 300 million VND being equivalent to a 2-floor house and 1 attic over the land area of 65.7 square meters in land lot number 2, Q District, Hanoi, with a map enclosed. Mr. H3 would receive the amount of 172,440,000 VND, Ms. T and Mr. H would receive 20 million VND as the repair costs to be paid by Ms. H, Ms. H1 and Ms. H2. Ms. H, Ms. H1 and Ms. H2 shall pay Mr. H3 the amount of 172,440,000 VND and pay Ms. T and Mr. H the amount of 20 million VND as the repair costs. To invalidate the certificate of land use rights over the land area of 162 square meters in land lot number 210 of cadastral map number 2 in the name of Mr. Pham Van H3 issued by People's Committee of QUYY District on September 10, 1987. To recognize the consent of Mr. Pham Van T, Ms. LUient T and their children being Pham T Thursday T2, Pham T Thursday T3, Pham T Ton T4, Ms. Phung TH4, her children being Pham TH5, Pham Duc H, Pham Duc M all waived their right to receive the inheritance and had no requests in relation to the land area of 110 square meters of Ms. V and Mr. H in land lot number 252, cadastral map number 2, Q District, Hanoi. To recognize the consent of Mr. Pham Van H3, Ms. Pham TH, Ms. Pham TH2, Ms. Pham TH1, Mr. Pham Van T, Ms. LUient T and their children being Pham T Thursday T2, Pham T Thursday T3, Pham T Ton T4, Ms. Phung TH4, her children being Pham TH5, Pham Duc H, Pham Duc M, plus no request for the court to settle the assets attached to the land of Ms. V and Mr. H, which are 4 thatched cottages, plus no request for the court to settle the funeral expenses, plus no requests in relation to land lot no. 253 in the name of Pham Van Q, land lot number 261 in the name of Pham Van T, land area of 189 square meters including land lot number 261B, land lot number 260 with the area of 94 square meters in the name of LUhenT TP, plus no request for the court to settle the transfer of the land use rights by Mr. T and Mr. D to other people, plus no request for the court to settle the amount of 8,733,000 VND. The judgment also dealt with court fees, right to appeal and interest amount on late enforcement of the judgment. On June 14, 2013, Ms. T, Mr. H and Mr. L submitted an appeal. In Appellate Civil Judgment No. 53/2014/DSBT dated April 4, 2014, the Appellate Court of the Supreme People's Court in Hanoi upheld the first instance judgment. On August 19, 2014, Mr. Pham Van H3 presented an application for cassation. In Protest No. 152/2015/KNDS dated May 28, 2015, the Chief Justice of the Supreme People's Court protested against Appellate Civil Judgment No. 53/2014/DSBT dated April 4, 2014 of the Appellate Court of the Supreme People's Court in Hanoi and requested the Judicial Council of the Supreme People's Court to conduct cassation procedures to set aside Appellate Civil Judgment No. 53/2014/DSBT. Dated April 4, 2014 of the Appellate Court of the Supreme People's Court in Hanoi and First Instance Civil Judgment No. 24/2013/DSST dated the 30th and the 31st of May 2013 of the People's Court of Hanoi, transfer the case to People's Court of Hanoi to reconduct first instance procedures. At the cassation hearing, the representative of the Supreme People's Procuracy agreed with the protest by the Chief Justice of the Supreme People's Court. Part 4 Findings of the Court. 1. Mr. Pham Van H. passed away in 1978, and his wife being Ms. No TV had 7 children being Mr. Pham Van H3, Mr. Pham Van D. passed away in 1998, Mr. Pham Van T, Mr. Pham Van Q. passed away in 2000, Ms. Pham TH, Ms. Pham TH1 and Ms. Pham TH2. When alive, Mr. Pham Van H and his wife had thatched cottages on the land area of 464 square meters in H Street, Q District, Ha Tây Province, currently Hanoi. The land had been given to them in the land reform period. 2. After Mr. H passed away, Mr. H3 and his wife being Ms. N watched over the land and houses. Ms. V and other children went to the south to participate in the new economic program. In 1983, Mr. H3 and his wife moved to another place to live but continued managing the land and houses. The People's Committee of Q District confirmed that the cadastral books stored at the People's Committee showed that the land of Mr. H and Ms. V was divided into 2 lots in which one was coded 210 with the area of 162 square meters in the name of Mr. H3 and the other was coded 213 with the area of 300 square meters in the name of Mr. T. After that, Ms. V returned to the land and house and stayed there until she passed away in 1994. After her return, Ms. V organized a family meeting to divide the land area into 4 separate parts for her children, who had no objections and agreed to carry out the said division. Therefore, Mr. T's and Mr. H3's agreement with Ms. V in the division of the land area of 464 square meters indicated that Mr. T's and Mr. H3's names were just recorded on the cadastral documents, and the land and houses belonged to Ms. V and Mr. H, but not yet divided. Mr. H3 failed to provide evidence to prove that the land area of 162 square meters was of his separate asset. 3. The land areas given to Mr. D, 94 square meters, Mr. Q, 78 square meters, and Mr. T, 189 square meters, had been received by them, who then were granted certificates of land use rights or transferred their land to other people who had carried out registration procedures for amendment. Up to now no one has brought any dispute on these land areas. The remaining land area of 110 square meters, width of 7 meters next to the street, had been managed by Mr. H3. In 2004, it was not until when he divided the said land area among his children that Ms. H, Ms. H1 and Ms. H2 raised a dispute to claim the land area of 44.4 square meters. In fact, at the time that Ms. V divided the land, her children were grown up and some of them had their own families who had the need for land to build houses. Mr. H3 already had land and houses while Ms. H, Ms. H1 and Ms. H2 were in Benfuk, so that these four people had no need to build houses at that time. Mr. T acknowledged that Ms. V divided the land and her children all agreed, and Mr. T confirmed that Mr. H3 managed the land area that Ms. V had divided among Mr. H3, Ms. H, Ms. H1 and Ms. H2. Mr. T recommended that the court rule that Ms. H, Ms. H1 and Ms. H2 shall be entitled to their assets. Mr. D's and Mr. Q's wives, being Ms. T and Ms. H4 respectively, and their children, despite being unaware of the division, agreed that Ms. V had divided the land among her children and they had no further requests. The land area of 110 square meters was therefore for Mr. H3, Ms. H, Ms. H1 and Ms. H2. As such, there is sufficient basis to determine that Ms. V had divided the land among Ms. H, Ms. H1 and Ms. H2, and this part of the land was managed by Mr. H3. 4. Based on the aforementioned evidence, there is sufficient basis to determine that Ms. V and Mr. H as heirs agreed on the division of the common property, the land and houses of Ms. V and Mr. H in 1991, and there is sufficient basis to determine that Ms. H, Ms. H1 and Ms. H2 were entitled to the land area of 44.4 square meters within the land area of 110 square meters. The division had been in fact carried out and registered in the cadastral documents. The division agreement does not violate any heir's rights and interests, and no one is disputing it, so that there is basis to determine the houses and land are no longer the estate of Ms. V and Mr. H, but the assets of individuals. Therefore, Ms. H, Ms. H1 and Ms. H2 are only entitled to initiate a lawsuit to claim the land area of 44.4 square meters which they lawfully own due to the division in 1991. There is no basis to accept the request for dividing the estate of Mr. H and Ms. V because the inheritance from the parents no longer existed. 5. According to the first statement of claim and testimony before the first instance court accepted to settle the case in 2010, the plaintiffs had claimed only the land area of 44.4 square meters. After the acceptance of the case for first instance procedures, the plaintiffs changed their testimonies and requested division of the estate of the land area of 110 square meters, being the assets of their parents that Mr. H3 managed, which had no basis. The first instance court failed to clarify the involved parties' testimonies on the changes to their claims and ruled to accept the request for division of the estate of the land area of 110 square meters, and the appellate court upheld the first instance court's decisions in the first instance judgment, which had no basis. Part 5 Rules. In light of the aforesaid reasons, pursuant to Article 291.3, Article 297.3 and Article 299.2 of the Civil Procedure Code, amended and supplemented in 2011, Rules 1. To set aside Appellate Civil Judgment No. 53/2014/DSBT dated April 4, 2014 of the Appellate Court of the Supreme People's Court in Hanoi, and First Instance Civil Judgment No. 24/2013/DSBT dated May 31, 2013 of the People's Court of Hanoi regarding the case on dispute on inheritance being land use rights, between the plaintiffs being Ms. Pham Th, Ms. Pham Th2, Ms. Pham Th1 against the defendant being Mr. Pham Van H3. 2. To transfer the case to People's Court of Hanoi to conduct first instance procedures in accordance with the law. Contents of the case law. 4. There is sufficient basis to determine that Ms. V and Mr. H as heirs agreed on the division of the common property, the land and houses of Ms. V and Mr. H in 1991, and there is sufficient basis to determine that Ms. H, Ms. H1 and Ms. H2 were entitled to the land area of 44.4 square meters within the land area of 110 square meters. The division had been in fact carried out and registered in the cadastral documents. The division agreement does not violate any heir's rights and interests, and no one is disputing it, so that there is basis to determine the houses and land are no longer the estate of Ms. V and Mr. H, but the assets of individuals. Therefore, Ms. H, Ms. H1 and Ms. H2 are only entitled to initiate a lawsuit to claim the land area of 44.4 square meters which they lawfully own due to the division in 1991. There is no basis to accept the request for dividing the estate of Mr. H and Ms. V because the inheritance from the parents no longer existed.